Arkansas 2017. A 45-year-old widow receives $3 million from her husband's estate in the first year after his untimely death at the age of 50. Monthly checks averaging $13,000. Access to discretionary distributions. But there's a problem. She doesn't control most of it. She's financially provided for, but she's not financially independent. Every major decision requires approval from a trustee, the same lawyer who wrote the premarital agreement and who drafted her husband's estate plan. Want something significant? Ask permission. Need extra funds? Justify it. Disagree with the trustee's decisions? Too bad. The trustee has absolute discretion. And the trust distribution directives? Secret, even from her. An even bigger problem are 3 no contest clauses. Challenge the trusts and you lose everything, not just future benefits, potentially everything you've already received. Today, we're examining how a widow's fight for financial independence collided with complex estate planning and whether the Arkansas Court of Appeals enforced a $1.4 million clawback that would leave her owing money instead of inheriting millions.
When fortunes collide with courtrooms, wealth managers, financial advisors, accountants, fiduciaries, and lawyers need real answers. Welcome to Wealth Litigated, where Professor Kelly Lease Murray, JD, lawyer, legal scholar, and retired Vanderbilt Law faculty, analyzes actual courtroom wins and losses in asset protection to deliver actionable insights that optimize your client's wealth outcomes. From explosive family feuds over fortunes to sophisticated financial fraud, each week we explore what worked to protect wealth and what exactly went wrong so you get it right. And now, here's your host, Professor Kelly Lease Murray.
This is episode 103 of the Wealth Litigated podcast, the No Contest Trust Trap, part 1 of 2 episodes about the Lassiter case, a 2025 decision from the Arkansas Court of Appeals, ending a 9-year legal battle with significant losses for everyone, including the lawyers. I'm Kelly Lease Murray, and this is Wealth Litigated, delivering all the drama of true crime without the blood. We don't just tell you what actually happened in court. We also show you why it matters to your professional practice and how it impacts your client's wealth outcomes. Let's gavel in. The No Contest Trust Trap concerns how a husband's estate planning while terminally ill became a surviving spouse's forfeiture trap when seeking control over future finances. Because 2 trusts and a pour-over will all contain no contest clauses, there were 6 potential challenges, any one of which would have disinherited the surviving spouse, the widow. A pilot's license condition, election to take against the husband's will, which was previously waived under the premarital agreement when they were married 13 years earlier, seeking to invalidate the premarital agreement, claiming against the estate outright, removal of the trustee, and filing a legal malpractice action against the trustee. What would you advise, knowing that she'd already received $3 million, that she has to run the table on any of those 6? She has to win on each one in order to avoid being disinherited. What would your legal advice be if you're a lawyer? What would your financial advice be if you're a financial professional or wealth manager? In addition to being disinherited prospectively, one of the big questions in this case is clawback. Can the trustee enforce recapture of a portion of that $3 million she received in the first year? I mean, the amount the trustee was seeking was $1.4 million out of the $3 million. He couldn't seek all of it because some of it was required under the previous premarital agreement. $3 million in the first year, she's risking $1.4 million in forfeiture, clawback, if any one of those 6 potential challenges was deemed a contest, violating the no contest clause of 2 trusts and a pour-over will. In the first year alone, she received $3 million. A portion of it was required under the premarital agreement, including $500,000 from a life insurance policy, half equity in 2 houses. One of those houses was sold, so she received over $350,000 from those. But $1.4 million was recoupable by the trustee under the no contest provisions if any of those 6 challenges was deemed a trust contest. What would you advise? One of the three legal opinions the widow received wrote this: "It appears the trust has left you in a much better financial situation than you would have been under the premarital agreement alone. Consequently, this may not be something you want to challenge." That comes from a 33-page letter recommending that the wife not risk forfeiture, not challenge the trusts. The timeline of events are really important, and that's why we have a detailed slide in the YouTube version of the podcast. From 2000 to 2016, the husband is the client of one lawyer, a one-stop shop. This lawyer is a lawyer, an accountant, and his law firm, accounting firm, also provides financial, insurance, and tax advice. Throughout the litigation, he's wearing many hats, and it makes it somewhat confusing to find out who is actually on the other side of the litigation from the wife, which hat this same lawyer, his law firm, and other lawyers in his law firm are wearing. In 2003, the husband in his late 30s, the wife in her early 30s, are considering marriage. It's his third marriage, it's her second marriage. He has two children from a previous relationship, and he is a high net worth individual. Not surprisingly, he and his lawyer propose a premarital agreement. The wife also has a lawyer. The premarital agreement is signed, and they're married. In 2003 to 2006, the husband amended his revocable trust. In 2006 to 2007, husband and wife are traveling out of the country. They have two small children together at this time. And the many hats lawyer and his one-stop shop law firm revised the husband's revocable trust at that point, add codicils for the wife in case one predeceases the other while traveling overseas. In 2015, the husband is diagnosed with cancer at the age of 49. And from 2015 until his death, May 31st, 2016, he works with the lawyer from the one stop shop. And the one stop shop has only one named partner. It's this lawyer. He has other lawyers working with him, but he's the named lawyer. He's working with the husband. He's revising the revocable trust, creating an irrevocable insurance trust, and a pour over will. While this is going on, while the husband is being treated for cancer, the wife lawyers up. She has 12 lawyers and financial professionals. She receives those 3 written opinions, one's 33 pages long. And from the husband's death, for 9 years, she and her team are in negotiations with the trustee and then litigation with the trustee, individual lawyers within that one-stop shop law firm and the entity trustees. It's easy to extract a theme of this case as generosity versus greed, and the courts, the trial court and the Arkansas Court of Appeals, do that. Husband's generosity, offering through the trusts more to the wife than the premarital agreement gave her, versus greed. The wife's greed, she wants more. She's trying to box out other heirs of the husband. And those comments are in the appellate briefs filed in this case. But it's also about control versus independence. Some of the terms seems like a divorce after death. Yes, there's a premarital agreement, but there are a number of restrictions on what was a high net worth marriage where she's receiving less. Now, the court dramatically reveals the husband's why, sort of in the middle of the opinion, and so we'll save that for now. But it's not just generosity versus greed. Thinking about it from the control perspective and seeking independence. Also, after the husband's death, the wife has 2 minor children of this marriage. The husband, when they got married, it was his third marriage, her second. He had 2 children from a previous marriage, and but at the time of his death, his 2 older children are adults. In addition to his 2 older children, his 2 minor children, other heirs to the trust besides the wife are the husband's 2 sisters. After the husband's cancer diagnosis in the fall of 2015 at the age of 49, the husband spends almost the rest of his life estate planning. He is a high net worth individual. The premarital agreement separated his corporate assets and other separate assets, except for 2 houses that were converted to marital assets. In the premarital agreement, the husband had to maintain a $500,000 life insurance policy with the wife as the primary beneficiary, and she had a half marital interest in 2 houses. In addition, she had a half marital interest in his W-2 earnings and also their joint accounts. But other than that, she waived her right to elect against his estate. She waived her right to his separate assets or appreciation in his separate assets. Another big issue in this estate planning is that the distribution directives were secret. Now, that's not uncommon in second and third marriages, especially when there are children, older children from an earlier relationship and children of the marriage at issue. But with 3 no contest provisions in 2 of the trusts and the pour over will, beneficiaries could object to any action taken by the trustee under the distribution directives, but could not challenge the distribution directives themselves and wouldn't know about the distribution directives. Even demanding that the distribution directives be revealed would be considered, according to the trustee, a contest challenging the trust itself, risking disinheritance. Another opinion that the wife had received before challenging anything in the estate was this: clearly, husband had a great deal of faith and trust in this trustee, which I understand is concerning to you for many reasons, not the least of which is you do not know for sure what the distribution directives state. You may never have access to the distribution directives, and any attempt to challenge the same in court could well result in you being disinherited. Now, think about it. The trustee, the primary trustee, is the husband's longtime lawyer from 2000 to 2016. The husband and wife marry in 2003, and this lawyer, the named partner of the trustee law firm, the one-stop shop, he's the one who wrote the premarital agreement, and there is reference in the appellate briefs that the wife viewed that premarital agreement as a cloud over the relationship. You know, it is entirely common and almost expected in second and third marriages when someone comes to the relationship with children from a different marriage, older children, wants to protect them in addition to any children of the marriage. So it is not uncommon, and it's certainly in a high net worth situation like this husband was. The premarital agreement, it's as a document made sense, but the wife viewed this as a negative, and reading between the lines from even the Court of Appeals decision itself, it seems like that lawyer for the husband is the nemesis of the wife. And we see even more animosity facts in the briefing by the wife's lawyers, briefing by the trustee's lawyers on behalf of the trustee. Not an appropriate characterization, but certainly eliciting facts that cast a negative light on their interactions together. The estate planning from 2015 through 2016 until the husband's death in May of 2016 included 2 trusts and a pour over will. The revocable trust was amended. It had existed. It was amended in 2003, amended in 2006. And quick sidebar, there's an amendment in 2003, apparently, this is referenced in the wife's appellate briefs, that negated the premarital agreement for a period of time, that the husband wasn't going to enforce it. And part of the litigation that the wife and her lawyers pursue is to make that the active document. Well, the husband, after his cancer diagnosis, working with his longtime lawyer, revises the revocable trust. He signs it 3.5 months before he died, so February of 2016. It specifically supersedes 1993, 2003, and the 2006 revocable trusts. It incorporates the premarital agreement, confirms that that remains in full force and effect, because the premarital agreement under its own terms requires the signature of both spouses in writing to make a change. The husband's mother is named as the trust protector, asterisk. The wife later objects to this. It includes the right to object to trustee acts under the distribution directives, but those directives are secret, and there is a no contest provision that, including demanding to know the distribution directives, is considered a contest. Even before this amendment is the irrevocable insurance trust from September of 2015. The husband was diagnosed with cancer before he and his lawyer create this document. It's funded by $15 million in life insurance. This doesn't even include the husband's separate property, which was separate from the premarital agreement before the marriage in 2003. He was a high net worth individual, companies, and other assets. And there's no discussion in any of this litigation what the disposition of that separate property was. But it's a good bet that his two children from a previous marriage who were adults at the time of his death, and his two minor children who were minors at the time of his death, and his two sisters, all of whom are beneficiaries, including his wife, but that the blood relatives I just named may be inheriting those separate assets. The wife, that was excluded in the premarital agreement, and it's not included in anything she's a potential beneficiary to. But the irrevocable insurance trust is funded with $15 million of life insurance proceeds. This trust also provides that the trustee can modify or amend the trust for favorable tax status, including a Q-tip qualifying trust. It has a no contest provision. And then, of course, the pour over will, upon death, pours into a living trust any of the decedent's assets not previously transferred to the trust. That has a no contest provision. Now, this is the phrasing of the no contest. This is from the revocable trust that became irrevocable upon the husband's death in May of 2016. Trust beneficiary who shall contest in any court any provision in this trust agreement shall not be entitled to any benefits under this trust. Any and all devises, legacies, and portions of the income or principal of this trust, otherwise provided to be paid to such person, shall lapse, and shall be paid, distributed, and passed as though such person had died prior to my death, leaving no lawful descendants. The trustee named in this trust is specifically authorized to defend at the expense of grantor's estate any contest or attack of any nature upon this trust or on any paragraph or provision of this trust agreement. Put a post-it on that. This language is critical to the outcome of the 9 years of negotiations and litigation. Lapse as though such person had died prior to my death, leaving no lawful descendants. That's the consequence of being disinherited under the no contest provision. It's not just that you're disinherited going forward. If you never inherited the assets to begin with, that is what the trustee argued supported the clawback. So that's the language. We're going to find out how it litigated. Drilling down on the revocable trust and the irrevocable insurance trust. The revocable trust superseded 1993, 2006. It's irrevocable as of May of 2016. And it divided the trust estate into 3 separate shares. This revocable trust included the Q-tip qualifying trust, the marital deduction trust share. The trustee had full discretion to elect Q-tip treatment of this trust. It was written correctly to qualify as a Q-tip trust. The wife had a life interest in income. That Q-tip trust was funded with $5 million of the life insurance proceeds, so it's $15 million. As a Q-tip qualifying trust, the wife has no access to the principal. She won't inherit it, but she is awarded $5,000 a month and then annually a $25,000 bonus if she's complying with the trust on the annual anniversary of his death. So let's just take a step back. This is a high asset individual, the husband, with a high asset marriage. This is probably well below the standard of living she's used to. This same revocable trust reincorporates the prenuptial agreement. And this is another legal issue. We need to see what the Arkansas Court of Appeals, how it litigates there. The prenuptial is a separate contract. It's not an estate planning tool. It's a prenuptial agreement. It was signed in 2003. It's a contract enforceable between the husband and the wife. It's enforceable after the death of either one of them, and it's enforceable against their estates. But why did the husband reincorporate it into his trust agreement? What's the purpose of that? What's the consequence of that? One of the legal challenges that the wife and her lawyers brought was to challenge the validity of the prenuptial itself. Well, it sounds like that's a separate challenge. That is, she's not challenging the trust. The trustee argued in opposition that because this revocable trust reincorporated the premarital agreement, confirming it remains in full force and effect, that challenging the premarital agreement is a challenge to the terms of being a beneficiary under the trust, and that alone would disinherit the wife. That's what the trustee argued. What would your advice be without knowing the outcome? What would your advice be to the wife risking the inheritance, risking not just prospective disbursements, but possibly recouping or clawing back of almost half of the first 3 million? Is it worth it? She has to run the table. She has to win on every potential challenge to the trust. Any one that is deemed a contest disinherits her. On the right-hand side, we're looking at the September 2015 Irrevocable Insurance Trust. And this one includes a curveball that we're going to spend time in this part 1 on. The curveball relates to a pilot's license contingency. And if this contingency is met, $2 million out of the $15 million life insurance proceeds would be set aside in trust for the wife. She doesn't control it. She would be the beneficiary of it. So she's not just given $2 million. She becomes the beneficiary of that trust, but only if the pilot's license condition precedent is met. Why? Why is there a pilot's license condition precedent? We're going to look at it, both the terms of it, what purpose it might have served, and how it all litigated in the end. This is the pilot's license curveball. I'm calling it curveball. It's actually a condition precedent. But let's start with what the FAA says about how to actually be qualified and authorized to fly any aircraft. Quote, become a pilot. First step. Decide what you want to fly. FAA rules for getting a pilot's license or certificate differ depending on the type of aircraft you fly. You can choose among airplanes and other flying machines. Pilot's license is not the precise term, it's slang, but even the FAA uses it, which is my point in showing you this quote from the FAA website. You don't get a pilot's license, you get an airman's certificate, and that is after you are deemed qualified to physically fly the aircraft you are licensed for. So that's the airman's certificate. But there's more. You also need a separate document. You need an airman's medical certificate. The airman's certificate, loosely described as the pilot's license, generally does not expire. It can be revoked, but it doesn't expire. The document that expires is the airman's medical certificate because your health may change. For example, there's litigation where the holder of an airman's certificate had his airman's medical certificate revoked because he was under certain medication that the medical examiner deemed dangerous for operating aircraft. So it was prescription medication, but the challenge was, well, this will make you unsafe in the air. Keep in mind, the airman certificate, the pilot's license, is not the only thing you need to authorize to operate an aircraft. You also need a current airman's medical certificate. So here's the curveball. The trust language requires that the husband, at the time of his death, quote, have an active pilot's license, close quote. Wait a minute. The husband is the pilot. He knows he needs two things to be authorized to pilot an aircraft. He knows he needs an airman's certificate, and he knows he needs an airman's medical certificate, a current and valid airman's medical certificate. At the time this trust, the Irrevocable Insurance Trust, is written, September 2015, the husband's already been diagnosed with cancer, and he dies almost 9 months later. If he's being treated aggressively, radiation, chemo, there's no indication what type of cancer it was or what type of medical treatment he received. But hypothetically, if he's being aggressively treated for cancer, maybe that would void his medical certificate, his airman's medical certificate, if it was current at that point. Which begs the question, was this something that could ever possibly happen? Was the husband ever qualified to fly an aircraft after he was diagnosed with cancer? And that detail is critical to the condition precedent and that $2 million additional trust. Here's the actual language. Under 5B2, if the husband has an active pilot's license at the time of his death, then $2 million shall be allocated to a separate trust share specifically for the benefit of the wife. However, in the event the husband no longer maintains a pilot license at the time of his death, then the distribution under this section shall be void. I have two comments on this. First, contract drafting. When you are using a phrase, especially a legally significant phrase, you should not vary the phrasing if it means the same thing. Under the canons of contract construction, when something is revised and phrased differently, that confirms a different meaning. So if you mean it to mean the same thing, don't change it. Why did this experienced lawyer, husband's lawyer from 2000 to 2016, write it this way? Has an active pilot's license in the first clause, but then no longer maintains a pilot's license. However it's phrased, it should be phrased the same. But here's what would be even better than choosing the first phrasing or the second phrasing. Refer to the FAA requirements. If this incorporated the objective criteria of the FAA before someone can actually pilot an aircraft, it's not just the airman's certificate. You also need a current and valid airman's medical certificate. You need two things to pilot a plane lawfully, and you have to have your medical certificate with you. That's what should be here. The husband knew he needed the two things. He's the pilot. Maybe his lawyer didn't know, but something this important, that's worth an internet search. What does it take to pilot a plane? Is it really called a pilot's license? It's not. Even the FAA uses that slang, but technically pilot's license is slang. This led to litigation about the meaning of active pilot's license. Well, take a step back. Before litigation, the trustee, who's the person who supposedly wrote this language, after the husband's death, the trustee hires an expert to opine what this means. That should not happen. The person who wrote this language with the lawyer has inside information of what the husband subjectively understood this to be for. Even though it may not be written or defined in the irrevocable insurance trust, the trustee, the lawyer, the only named partner of the one-stop shop, he was present when he helped write this for the husband, knew that what the husband meant, didn't achieve uniformity, and didn't incorporate the FAA. So it's strange that a provision that this lawyer wrote, he now is bringing in what he deems as an expert to give him an opinion. I don't think the expert's opinion is the correct step. The correct step would be to look at the federal statute, the Code of Federal Regulations for this FAA licensure process, and to look at cases interpreting the meaning of those statutes, because lawyers generally cannot testify in court for their opinion of the interpretation of a statute or a regulation. And that's really the equivalent of what the trustee is doing here. Now, to be fair, the wife and her lawyers also get an expert opinion, and they opine the same thing. The wife doesn't react the same way the trustee does, but they opine the same thing. They opine that you need a valid airman's certificate and you need a current medical certificate to be pilot in command, to legally operate aircraft as pilot in command. That's the phrasing the trustee's expert uses. So you need two documents, but that's not what the trust says. The trust language is, it suggests this pilot's license. And that may have impacted the wife's decision as the client to pursue this claim. Because as a layperson, she can see the language. What do you think pilot's license means? On its face, it looks like it means the physical ability to fly a plane and earn that confirmation. You have an airman certificate, slang pilot's license, because you were tested on the mechanics of flying and you passed. That's not the same criteria or examiner as your medical certificate. That's a different test, it's a health test, and a different document. The medical certificate as acceptable evidence of physical fitness, protecting those who would exercise the privilege of a pilot certificate. Let's just look at this phrasing. This is from the FAA's website. The goal of the medical certificate is to protect those who would exercise the privileges of a pilot certificate. Well, a pilot certificate is slang for a pilot's license. And it is reasonable to interpret the phrasing the husband and his lawyer used in the irrevocable insurance trust as being only one of two documents. And if the wife understood it that way, I get access to a trust. I don't get 2 million outright, but an additional 2 million will be deducted from the 15 million life insurance proceeds for my benefit. And hey, his pilot's license, his airman certificate was valid at the time of his death. Well, I disagree with the trustee. And she did disagree with the trustee. But what she did next, there was a way to thread this needle to challenge the interpretation of that clause and potentially not trigger a contest and be disinherited under the no contest provision. Because the main objection here is that the trustee is misinterpreting his own less than ideal phrasing in the irrevocable insurance trust. The condition that the husband have an active pilot's license. If the condition fails, then that 2 million segregated in an additional trust benefiting only the wife is void and she doesn't get it. The purpose of the $2 million trust was included in the irrevocable insurance trust to maintain the wife's lifestyle with trustee discretion on the payouts. And if the condition precedent was not met, then the remaining beneficiaries would continue to benefit from that 2 million as part of the remaining life insurance proceeds. So what was the husband's pilot status at the time of death? He had a valid airman certificate. Those don't expire. He did not have a current medical certificate, and we don't have in the appellate opinion or in the briefing on appeal when his last medical certificate expired. If it was expired before September 2015, that would be even more concerning. Or was it invalidated by his cancer diagnosis and possibly aggressive treatment for cancer? Because pilots with an airman medical certificate are required to notify the FAA, the appropriate medical portion of a change in health that would make it unsafe for them to be in command of an aircraft. So to be legally authorized to fly, you need two things, not just one. The trust suggests it's one document. It looks like it's one document. This is the trustee's investigation. The trustee retains an Arkansas attorney who's an FAA certified flight instructor and designated pilot examiner to determine the requirements for, quote, an active pilot's license as specified in the trust document. A lawyer cannot give a legal opinion to a court. This actually depends on the FAA statute and the applicable Code of Federal Regulations, not the opinion of an attorney who's also an FAA flight instructor. We don't need this expert opinion. The wife gets her own expert, and they both conclude that the husband needed two things to command an aircraft. And the trustee's expert phrases it as valid and current, doesn't use the word active, uses valid and current. So why did the trust document itself use the term active? The actual term is valid and current, and the trustee's expert opined, that the husband had a valid airman certificate, the physical pilot's license, but he did not have a current FAA medical certificate, which was required to legally operate as a pilot in command. That was the phrasing. So why wasn't that phrasing used in this curveball condition? So the expert concluded that the husband was not lawfully authorized to exercise his privileges as a pilot in command at the time of his death. Yes, but that's not what the trust said. So we have an ambiguous provision, and the wife argued that the curveball pilot license phrasing is ambiguous. But as a legal matter, if it is ambiguous, the wife absolutely would lose. She would lose because there are two reasonable interpretations. One reasonable interpretation is the airman's certificate, but another equally reasonable interpretation is the FAA requires two things to physically fly, and what they really meant is, can he actually fly a plane? But still, it's concerning that this is even a condition precedent. What in the world is this additional $2 million for the wife to maintain high asset lifestyle she enjoyed during this 13-year marriage? Why is it contingent on a pilot's license, which may have been, the medical certificate may have been invalid as of the time this provision was even created? So the wife's expert opines the same thing, and that's held against her throughout. But the husband's lawyer, the only named partner of the one-stop shop, the lawyer, accountant, financial, insurance, and tax advisor, was more than a mere scrivener, and he could have written this in a way to be clear and unambiguous and possibly prevent anyone from challenging that provision, because if that clause had incorporated the FAA statute and code of federal regulations that you need two things valid and current to operate an aircraft, to be in command of an aircraft, there would have been no dispute at all. But the other aspect of this, it really looks like this was void ab initio, void from the start. This is like, psych, just kidding. It reminds me of Lucy pulling the football away from Charlie Brown, and that is a very overused metaphor. But it really looks like, based on the dates, September of 2015, the husband's already been diagnosed with cancer. He dies about 9 months after that. That this is written, he could not fly then. That he could not fly as of the time he signed the irrevocable insurance trust. So this condition precedent had already failed even before the ink was dry. Which brings me back to why. Why condition this additional $2 million, supposedly to bring the wife back up to the marital standard of living, even though she's received quite a bit under anyone's measure in the first year after the husband's death? She enjoyed a high asset lifestyle, and this looks like it was lower than that high asset lifestyle. So that additional $2 million trust for her benefit was intended to bring her back up towards the marital lifestyle. But it's contingent on qualifying to be a pilot in command, and he didn't qualify even as of September 2015. This was never going to happen, so why even do it? I have my theories. I want you to think about yours. Unlike the trustee hiring a lawyer who's also an FAA instructor, and unlike the wife whose lawyers hired a separate expert, let's look at some cases interpreting the United States Code and the Code of Federal Regulations. So in the Cooper case from 2011, they revoked an airman and medical certificate. So both documents were revoked because this person falsely answered no on the medical certificate renewal application, asking if he had been arrested for alcohol-related motor vehicle incident. It's a bit of a shame in the actual facts of this case. He did disclose it to the FAA. He just didn't disclose it on the medical certificate renewal. So he didn't hide the arrest, but he didn't check the correct box when renewing his medical certificate, and they revoked both his airman certificate and his airman medical certificate. This case confirms those are two separate documents. They didn't just revoke one, they revoked both. In the Bullwinkle case from 1986, held that an airman medical certificate and those proceedings are adjudications for the purpose of granting or renewing a license. This supports the trustee's argument that the phrase active pilot's license includes both the ability to fly and the medical clearance to fly, because a medical certificate is a licensing procedure. So the quote from the case, thus the airman medical certificate is definitionally part of an FAA certificate or other form of permission and hence a license. I also have on this the Code of Federal Regulations and the statute it's based on. The statute defines a license as the whole or part of an agency permit, certificate, approval, registration, or other form of permission. That would include the medical certificate. The Code of Federal Regulations, airman certificate means any certificate issued by the FAA to an airman and shall include medical certificates required. All of this supports the trustee's interpretation. And any time a condition precedent in an estate planning document, anytime you can use an objective measure like the United States Code and the Code of Federal Regulations and Federal Aviation Administration, any department like that, that's what should be done. That is precise, unambiguous, and really could preempt beneficiary challenges. There was a way to thread this needle. There was a way for the wife and her lawyers to challenge the trustee's interpretation of the curveball, of the condition precedent that the husband have a, quote, active pilot's license, close quote. There was a way to thread the needle to question the interpretation by the trustee without challenging that provision itself. Hey, trustee, we disagree with you. You and the husband use the phrase active pilot's license. That refers only to the airman certificate. It doesn't say medical certificate, so it's not the medical. So challenging that interpretation in a declaratory judgment action is far more likely to not trigger the no contest provision. Now, your results may vary in your jurisdiction. You need legal advice to research this first to make sure that questioning the trustee's interpretation of a condition precedent is not challenging the term itself. But that's not what the wife and her lawyers chose to do here. They did not thread the needle. They sent a demand letter. The wife demanded $2 million within 3 weeks. Claimed the provision was ambiguous. Sidebar, if it's ambiguous, the wife loses under that the USC and the Code of Federal Regulations for the FAA. If it's ambiguous, she loses. But this letter argues it's ambiguous, alleges the husband's execution required her consent and approval, despite her own expert opining the same thing as the trustee's expert. And that's what the trustee emphasized. That's what all the courts emphasized. Hey, your own expert confirmed you can't fly a plane without both. And that's what it probably meant. Because the courts refer to this provision as unambiguous, what they're actually doing is going beyond the phrasing. They're looking at other information. Well, that's not unambiguous. They're actually treating it as ambiguous. The wife just loses under that ambiguity. So, challenging the trustee's interpretation might have threaded the needle, but this demand letter did not. The trustee denied the wife's claim, cited the trust language, consulting with a pilot, and that the husband was not authorized to fly. Well, that's not what the language said, but that was the result. So, the curveball, why? Why is it in there? And why did the wife and her lawyers not try to thread the needle? Why did they act on this letter? So after the trustee tells them, I'm not complying with your demands, this is one of the claims that the wife litigates. Remember, she has to run the table. She cannot have a single contest of the trust terms. Any one of those potential 6 we looked at the start, if one of them is a trust contest, she's disinherited. And this is all that was needed to disinherit her. Takeaways from the pilot license contingency. Consistently use terms for the same condition precedent. Active pilot's license versus fails to maintain a pilot's license. That's not consistent phrasing. Be consistent, but even better than that, incorporate the objective criteria. The FAA requirements to lawfully exercise the privileges of pilot in command at the time of death. The phrasing that all the experts used, that's what should have been in this condition precedent. And specify he needs a valid and current airman certificate and an airman's medical certificate. The only one that expires or can be terminated based on a change in medical is the medical certificate. The key here for any client is to avoid the no contest. So challenge the interpretation of the language, not demanding $2 million outright, because that contravened the express, unambiguous provision of this contingency. The trust itself never allocated $2 additional million to the wife. If the curveball was met, if the pilot's license contingency was satisfied, it would have been $2 million in a trust for the wife's benefit. She demanded in her letter and then litigated for the $2 million outright. That was a trust contest, and she's already disinheritable from everything under the 2 trusts. Our 6 no contest contests, pilot's license condition, she's already lost. It's already a trust contest. And it's already a trust contest. So even if she could win, all she would keep would be the $2 million. She's still disinherited. Electing to take against the husband's will, that was waived under the premarital agreement. Seeking to invalidate the premarital agreement, yes, she can try that, but that may also disinherit her. Claiming against the estate outright, trying to remove the trustee, and the trustee legal malpractice action. Based on what she received early on, the phrasing that the trustee uses is the wife should have been happy with what she got. Well, a client doesn't have to be happy. But the math, the financial advice to support the legal advice that challenging this trust with 3 no contest provisions was a bad idea, especially the prospect of being not only disinherited prospectively, but maybe owing the trust money. So instead of inheriting millions, she's in debt. She would have to pay back 1.4 million out of that first 3 million and no more income from the trusts. What would you advise? Thank you for joining us. Stay tuned for a preview of our next episode. Now, in part 2 of the Lassiter case, we examine whether you can lose a settlement payment to the law firm who allegedly committed the malpractice, and what happens when your former lawyer, now serving as trustee, becomes your legal adversary. This is episode 104 of Wealth Litigated, The Malpractice Trap, Trustee's $2 million clawback attempt. Part 2 of 2, the Lassiter Trust Dispute, ending a 9-year legal battle with significant losses for everyone, including the lawyers.
This is Wealth Litigated, where the real courtroom battles we analyze today are your roadmap to stronger asset protection and better wealth outcomes. Follow us on your favorite podcast platform or subscribe on YouTube so you never miss a weekly episode. Questions or cases? Visit wealthlitigated.com/questions. This show is for informational and educational purposes only and does not constitute legal, tax, or financial advice. No attorney-client relationship is formed. Consult a qualified professional for advice specific to your situation and jurisdiction. Wealth Litigated is now adjourned.